Well, your tax dollars are being wasted. That's what local defense attorneys tell 6 Investigates. They say the Nueces County District Attorney's Office is forcing them into needless trials, and it's costing you money, especially when the defense is court appointed. That means your tax dollars are paying for both the prosecution and the defense. Investigative reporter Andrew Ellison joins us now live in the studio with more.
You know, Lee, in lawyer speak, it's called overcharging. It's when a defendant is charged with something like a first-degree felony, but ends up being convicted of a much lesser charge. Local defense attorneys say it's happening more often. They call it a waste of jurors' time and a waste of your money.
Could it all have been avoided? Sure.
A 10-count indictment.
As long as they're burning your money or my money, taxpayers, they don't have any concept of economics.
A plea offer for 35 years in prison.
They're getting marching orders written in the file.
A 3.5-week trial.
The taxpayers should see how much money is being wasted in trials that maybe shouldn't be going to trial.
The result, the defendants got probation. We're talking about Ryan and Heather Sanders, 2 parents who were charged with 7 counts of first-degree child abuse and several lesser charges after the family was found living out of their car on the beach. Each one of those first-degree charges is punishable by up to 99 years in prison. These parents couldn't afford representation, so the court appointed defense attorneys for them, meaning taxpayers paid the bill. The Sanders trial cost over $150,000 in attorney's fees alone. One of the defense attorneys on the case, Terry Shamsey, says the whole trial could have been avoided had the DA's office charged it correctly. He says it's likely a deal would have been cut.
It should have been a $5,000 to $8,000 case.
Shamsey says this is a pattern with the DA's office. Prosecutors bring unrealistic charges, then offer unrealistic plea deals, leaving defense attorneys with no choice but to go to trial.
I couldn't sleep at night if I told my client to take something that was completely overcharged, completely ridiculous. It wouldn't be right. It wouldn't be fair.
Lisa Greenberg was recently appointed to defend a homeless man charged with criminal trespassing at a local Stripes. She says he was talking to the wall, clearly mentally ill, and yet even this case is going to trial.
You could kick this case, but they're not going to, so I'm going to try the case, and I'm going to tell those jurors, I'm going to tell every single one of those jurors, this taxpayer money could have been spent on resources to help this man. You're not going to criminalize the mental illness out of him. You know, this is where prosecutorial discretion should kick in.
She's saying the prosecutors should have the ability to make reasonable deals, but as defense attorney Mark Stolley has observed, they're not always given the chance.
When they open the file, they'll say, you know, I can't offer you anything but X number of years in prison. And that's from the higher up.
We charge what the law allows, period.
District Attorney Mark Skirka says his office charges according to the evidence it collects, adding that the criminal justice system only works in one direction.
We can't undercharge and then go up, but the jury can make it go down.
As for the plea deals, Skirka says his prosecutors are only given marching orders on felony cases, or cases with repeat offenders.
When you have an attorney trying felonies who've only been here a year or two, they don't have the experience of that 10, 15-year defense attorney.
Defense attorney Mark Gonzalez says whatever the intent is, there's a huge gap between what prosecutors are offering and what is resulting from jury trials.
So how do I know that, right? Well, I go to trial every week. And how do I know that they're not reasonable? Because the offer they give me, whether it's 40 years and I get them probation, or the offer they give me is 40 years and I get them 5 years.
When they overcharge, what's the result? The result is the taxpayers get hit for the bill.
Of course, it also costs money to keep many of these defendants in jail before and during trial if they can't bond out. The DA says cost is never a factor when deciding whether or not to try a case. He says that would conflict with the office's duty to seek justice. Jen?